Peace, family. This is your brother TWEA coming at you again with another donational round. It's going to be a 3-part video going into detail regarding the Trading with the Enemy Act and how things are set up in real time and how they're using these acts or these acts of war or time well, really actually in the wartime since 1933 when the emergency was declared. I'm going to go over some details regarding that, and this is coming from Corpus Juris Secundum, War and National Defense section. I don't know which book this is, but as you can see at the very top, it's from Corpus Juris Secundum. But before I get into it, this is for educational purposes only. If you need any legal counsel, I suggest you seek your own legal counsel, such as an attorney. Or, of course, we have the option to do our own diligent research and come up with our own conclusions. I'm only sharing you my conclusions from what the things that I research, sometimes the things that I've done. But again, this topic is talking about trading with the enemy. What is a belligerent? What is military occupation? What is the alien property custodian and his functional powers? We're going to be talking about prize and booty of war. What it means to be neutral in a time of war. And, how it all applies, as I stated before, in my opinion, today. Well, I'm going to first start with Corpus Juris Secundum, which you see here on my screen. Section 22, return or recovery of property or proceeds. Again, this is part 1 of 3 parts. Let's get into it, because I will be hopping from different document to document to kind of highlight the point that I'm trying to get across here. In providing for the seizure of property of aliens under the Trading with the Enemy Act, Congress did not intend to confiscate the property of citizens or alien friends, or citizen or alien friends. All right. A provision of the Act, therefore, makes available to a person who is not an enemy or an ally of an enemy certain judicial administrative remedies for the return of property erroneously seized. Let's go to the alien property custodian part, and I'm going to return to this document because we're talking about property being seized, and we want to know who's in charge of such seizure of property. Right? Let's go here. The work of the alien property custodian by Paul V. Myron. The control, seizure, and administration of enemy property is a right inherent in every wartime government. The framework of our Constitution apparently provides for the exercise of this right by Congress in Article 1, Section 8, Clause 2, which states that Congress shall have the power to declare war, grant letters of marque and reprisal, and makes rules concerning captures on land and water. Article 1, Section 8, Clause 18 further grants to Congress the auxiliary power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. And Congress is thereby vested with the power not only to make rules concerning captures on land and water, but also authority to provide all appropriate means which are conducive or adapted to the accomplishment of that end, in which the sole judgment of Congress will most advantageously affect the purpose sought to be accomplished. Under this constitutional grant of power, Congress may enact such legislation as is necessary to deal adequately with property located in the United States, in which enemies or their adherents have an interest. All right. That's interesting to talk that sentence. Right? The Trading with the Enemy Act passed shortly after the beginning of the First World War. It's a concrete example of the exercise of this right by Congress. This act delegates certain powers to the president and to the alien property custodian, authorizing the seizure and control of all property located in the United States, owing or belonging to, or held by, or held for, by, on account of, or on behalf of, or for the benefit of a person in enemy country or in enemy occupied territory, or a person proclaimed by the president to be an enemy. Okay? Let's go here to representational functions of the Attorney General, which is the Alien Property Custodians, Fordham Law Review, James L. Duncanson. All right, it says the Office of Alien Property Custodian during World War II has been performed as an important function but was not exercised by the custodian during the First World War, which is World War I, which we got your Trading with the Enemy Act. Namely, the representation of persons who, because of their presence in enemy countries, so it's because of your presence in enemy countries or enemy occupied territory, were unable to defend themselves or to appoint someone to represent them in court or administrative actions or proceedings in the United States. This is huge. Why? Because you have been behind enemy lines. Because the man is of the United States of America. You've been doing commercial business in the United States, which is under the enemy's jurisdiction. You find yourself in a situation, it's hard for you to defend your interests in these administrative courts of actions or proceedings that are within the United States. Let's keep reading, because I don't want to sound like a kook or someone who lost his mind, for those who don't really have the in-depth interpretation of what really was going on, beneath the veil of government and what has happened throughout history, and how we, in my opinion, of course, and some facts can show, we've been in a state of war for a very long time, and we've been conquered and occupied by these foreign powers. So, though you don't see bullets flying, you can still be under an act of war without bullets flying. You can still be under an occupation without those bullets flying. Okay, occupation could be an agreement. All right, it's like treaties, but those are different agreements. But let's continue though. All right, the declaration of war between the United States and the Axis powers in 1941 focused attention on Trading with the Enemy Act of 1917, which most of us know that. If you are watching this video, I'm certain, or quite certain, that you've probably already heard or read about the Trading with the Enemy Act, so I really don't have to go into that. But I'm going to go into the details of the Alien Property Custodian so you can see how this all plays in what we call the proper administration of your property and regarding your estate. All right. In order to implement existing legislation to meet the problems created by our entry into World War II, the first War Powers Act in 1941 was enacted by Congress, approved by the President on December 18, 1941. The third Title III of this Act amended the first sentence of Subdivision B of Section 5 of the Trading with the Enemy Act of 1917, as amended. Legislation conferred broad powers upon the President or any agency he might select to deal with property or interests therein of nationals of a foreign country during time of war. Now, we know the President is a commander-in-chief, and that's going to be important. That's why I suggest you listen to all three parts, because I'm going to tie everything we're talking about together here, okay? So, this is from the law of belligerent occupation, JAGS Text number 11, Judge Advocate General School in Harbor, Michigan. I think it was written in 1944. But I'm going to tie everything here into three parts. So it's very important you follow and stay with me. Also, don't forget to like and subscribe. All right. Where was I here? All right. So let's keep going. All right. No. Let's read what Article 3 contains. These three provisions that was mentioned above. Okay. Let's read that. Article 3 contains three provisions. 1. Section 5B, page 2305 of the Trading with the Enemy Act has been continued down to the present time. The existing system of foreign property control, commonly known as freezing control. I'm sure those has heard there's a freezing or a block on our states or on our assets to where a lot of us can access those funds because there's a freezing or a block on it. And I'm sure there's OMB forms of the nature or some form of treasury form or trade direct form. I don't know what this again, in my opinion, that may be able to unlock those assets. Let's keep going. It's based on the subdivision as last amended on May 7, 1940. That subdivision of Section 5 as it is now in effect, however, does not give the broad powers to take, administer, control, use, liquidate, etc. such foreign-owned property that would be given by Section 301 of the bill. At present, the government exercises supervision over transactions in foreign property, either by prohibiting such transaction or permitting them on condition and under license. So they're permitting certain transactions, but you have to have a license. I'm sure the license is your bond. It is therefore a system which can prevent transactions in foreign property prejudicially to the best interest of the United States, but it is not a system which can affirmatively compel the use and application of foreign properties in those interests. Okay. That's what Section 3 is talking about here. Let's keep going. On March 11, 1942, the President of the United States, by Executive Order 9095, established the Office of Alien Property Custodian of the United States, and on July 6, 1942, the Executive Order was amended by Executive Order number 9193. Section 5 of this Executive Order authorized the Alien Property Custodian to issue regulations covering the service of process or notice upon any person within any designated enemy country or any occupied territory in connection with any court or administration action or proceeding within the United States. So who's the enemy here? Is the United States considered the enemy occupied territory, or is it the United States considered the enemy? Is the United States considered the occupying enemy? Because in the law of occupation, as you will hear soon, we're dealing with someone who's two belligerent enemies, right? And it's a occupation of one or the other most of the time. So if we declared an emergency, a banking emergency, and we had to get a contract from a foreign entity, that foreign contract we're under is an occupation, whether you want to agree with it or disagree with it. Because I can show you where contracts, occupations, of areas, of countries, of nations can be done by contract and not war alone, or not war at all. All right, procedure set up by the Alien Property Custodian. The Alien Property Custodian, acting pursuant to the authority of the Trading with the Enemy Act, has amended an Executive Order number 9193, thereafter issued General Orders 5, 6, and 20. Okay. Let's go back here. All right. this here to you. Let's keep going down. Right back what we said earlier, the freezing and control. So prior to Japanese attack at Pearl Harbor, the United States government was exercising peacetime emergency control. This is all these words here, you guys, is going to be important because I'm going to link it all together in here, which is the law of belligerent occupation, Jack's text, the Judge Advocate General School. Okay, this is their military Colonel Reginald C. Miller, which is what they use. Okay, the military to be in particular, but we are in a military occupation, so the same doctrine, the same laws apply. The law of war. All right. The United States government was exercising a peacetime emergency control over transactions affecting property owned by nationals of the Axis and invaded countries pursuant to Section 5B of the Trading with the Enemy Act. At the time, the Axis was Japan, Germany, and Italy. And if you were a national of the United States, the alien property custodian was created to protect your property when you have to go to these foreign tribunals to have that property adjudicated. Okay? And the Attorney General is to be noticed of such adjudication of that property of a foreign national. If it's not done, then they don't have jurisdiction to continue that suit or that administrative proceeding. The plan of foreign national property control, commonly known as freezing control. Again, say it again, and I'm sure there's documents talking about freezing or unblocking the asset somewhere. Has to be. It was first designed to conserve the property against acts of the Axis powers. So it's basically preserving your property against foreign powers that may have forced or sold or, something of that nature. Secondly, to prevent transactions in foreign property which were prejudicial to the best interests of the United States than a neutral nation. The program administered by the Treasury Department limited and immobilizing, freezing the property of foreign countries of nationals thereof. All transactions in foreign exchange, credit, and other property involving the national of these two countries were subject to regulation by license. We're talking about Norway and Denmark at the time and freezing the property of the nationals. It gets better. I don't want to bore you all just reading. This method of control was permanently adequate to meet all requirements of a wartime government. Keep going. Okay, Section 301, 302, 303 of the First War Powers Act. And just I said earlier, the president is to decide who could enforce those powers vested in him. It says, granted the president operating through such an agency as he might choose, which might be the custodian in this case, power to investigate, notify, regulate transactions involving property in which foreign countries or nationals thereof have an interest, and to vest any property or interest of any foreign country or national thereof in any agency or person whom the president may designate. Such property or interest to be held, used, administered, liquidated, sold, or otherwise dealt with the interest of and for the benefit of the United States. Basically repeat what I said here. Let's go here to this here. The Executive Order 9193. That's kind of giving you a breakdown here, but I'm going to start here. The Executive Order, in general terms, authorizes the custodian to deal comprehensively with the problems that surround foreign property and its ownership control. The powers of supervision and control vesting of these two types of foreign and owned property are divided between the alien property custodian and the Secretary of Treasury. So those are the two people holding that power. Okay. While defining in detail the specific powers and duties delegated to each agency, the order provides that no person may challenge the validity of an act of either the alien property custodian or Secretary of the Treasury on the grounds, that the authority for such act was specifically delegated to the alien property custodian or the Secretary of Treasury or vice versa. All right. Under the provisions of Executive Order 9193, the custodian is authorized to take such an action as he deems necessary in the national interest and not the United States national interest, but the national interest, which is the people, including but not limited to the power to direct, manage, supervise, control, or rest the following classes of property. Property in which foreign nationals have an interest. It gives you the list of those properties. Ships and vessels. Read, if you go back and read John Bouvier and the Government Office manual style book and my videos, it was I was mentioning that the all caps is a vessel. Okay, that's the interest that you have as a foreign national, is an interest to your foreign vessel, which is your name, which is your ship, and the other property that you may have out there. Look, cash, securities as well. So we got out those securities that are in our names, right? Business enterprises, any property in the process of judicial administration. This is for my enemy nationals here, but this also applies up here. The custodian first task was to identify foreign property interested located in the United States and determine the beneficial ownership of such property. Let's keep going. All right. Types of control exercised by the custodian. In general rule, the custodian has followed the policy of vesting the power, property, or interests of persons in countries within the United States is at war within the limitations of Executive Order 193. In taking title to such property, the custodian is in a position to exercise complete control of the property or interest for the use and benefit of the United States, since by vesting all rights of former enemy owners to such property are vitiated. The custodian specifically authorized the vested property and interests of persons in occupied territory and of persons who are found by the custodian to be acting as cloaks for enemies when he determines such an act is in the national interest. Okay, so it's basically telling you here that the custodian is basically breaking down his vesting powers. Okay. Excuse this. This is not my notes here. I must say that for the record. I do not own this here. It came with the document, and I was like, hey, I can't remove it. Might as well stay. So this might give you a little help. It says, these MFers just admitted a trust in taking title, which is trust terms. With legal title, they are the legal owners, all property, and trustees for the benefit of the U.S. under war powers. And that's basically what it's saying in a nutshell. Okay? Well, let's go here. Go back to corpus juris secundum. All right. The provision of the Act therefore makes available to a person who is not an enemy or an ally of an enemy certain judicial administrative remedies for the return of the property erroneously seized. So we know who's in charge of this here regarding the Emergency Act. We know it's the Alien Property Custodian, which is the Attorney General. Okay. The provisions of Trading with the Enemy Act allowing for the return of property to non-enemy aliens. And the provision of the Act permitting the return of property to certain technical enemies and others deemed worthy of obtaining a return of property are mutually exclusive. However, no return may be made pursuant to either statute unless a notice of claim is filed within the time in the matter specified by statute. So this is giving you an idea of, if you want to claim that property, you have to put that notice out there to the proper party by notice of claim. When a statute doesn't provide it, which never depends on statute, I don't suggest you do either. But give your notice of the claim within the time and the manner specified by the statute. Well, let's see if we can find that time frame. I can leave it up to you to find it for me. I mean, gotta do your research, right? do it together. Let's go. Now I'll go back over here. All right, it says, thus a successful claimant is entitled to recover the property seized or the proceeds derived from a sale thereof by the custodian, together with all accumulations or interest actually received thereon. Now, this is also going to be important later because most of your property is deemed, right, to be lost at sea or in another foreign jurisdiction protection. It's been seized by another body that is not in harmony with your government. It's under the occupation. It's the property you're using and you're doing business with every day is trading with the enemy. That name you're using to do commerce is trading with the enemy. Like I said, it might go over a lot of you guys' head, which is okay. Hopefully it challenges you to dig deep and find out or attempt to see what I see. All right. Let's keep going. Apart from administrative remedy, the Act authorizes certain persons to institute a suit in equity. Wow. Not in at law, right? But in what? Equity. And specified federal district courts against the alien property custodian or the treasurer of the United States. Well, wait. It did say the Treasury Department here. Interesting. Very interesting. And it says, depending upon which has custody of the property, such a suit may be brought to establish any interest, right, or title which the claimant has in money or property held by the custodian or the treasurer. If the claim is established, the court will order the payment, conveyance, transfer, assignment, or delivery of the money or property so held to the claimant. So this is talking about the booties, what they call it, or prize. Because prize is the captures of goods amongst the seas at a time of war. And depending on who's in capture of that prize, whether it's the Attorney General or the Treasurer, that's who you may have to send your claim to give them notice of your interest. So when it's time, you can commit your acts in equity. So to show the unjust and unfairness or wrongdoing of such seizure of that prize. Because let's keep going here. I'm going back to the alien property custodian for a moment. See if I can find where I was at. No, I think that was for representation. See, look. Designation of attorney by the alien property custodian. So he designates his own attorney, which is a deputy, right? Deputy Attorney General. He's a deputy of the United States Attorney General, which is the one in your state. He's the deputy. And he's going to deputize somebody goddamn else. Alien property custodian upon the receipt of process or notice relating to property where it appears that a person within an enemy-occupied territory or a designated enemy country has or may have an interest. What is he giving y'all? A notice. And that's when he designates an attorney on his behalf to staff on behalf of such a person in the pending action or proceeding in accordance with Section 5 of the Executive Order 9193. what did we say here? You have to give notice? Who? Right? The administrative remedy need not be exhausted before a suit may be brought, but the filing of a notice of a claim for the return of property vested in the custodian is a condition precedent to the maintenance of an action. Wow. So if you want to, those funds you claim that you that's owed to you, if you want to access that, you're gonna have to give him notice first. Then bring your suit in equity. Okay? And when the frozen assets, they're telling you here how to block those assets in a time of war. A person may seek to obtain a license from the United States Treasury. We wonder what type of license that is. To unblock assets that have been frozen under regulations issued pursuant to the Trading with the Enemy Act, such as the Cuban Asset Control Regulations. The person seeking an unblocking order has the burden of showing that he or she is essentially an innocent recipient of property rights, that the funds have been blocked due to mistaken identity. Oh God. Oh God. Because that caps, it's not your identity. Do you hear me? Until you come with the correct identity, you can't claim that. That cap is an enemy. Using that caps is doing business as an enemy belligerent. But you're trading with the enemy. You got to come with your proper name to avoid mistaken identity, to have those funds released. That the party may seek to have such funds unblocked pursuant to the administrative procedures set forth by regulation. In amity law, the term prize is used to signify any goods which are the subject of a maritime or marine capture. Capture and condemnation are prescriptive and established modes by which the law of nations are applicable to maritime warfare is enforced. In order to constitute a complete capture, it is necessary and sufficient that there be such conduct as to indicate on the one side a submission or forced compliance with others' will. On the other side, intention to take possession of prize. No particular form of conduct is necessary to constitute a capture. So let's go back up. In order to constitute a complete capture, it is necessary and sufficient that there be such conduct as to indicate on the one side a submission or forced compliance with the other's will. Now, I highlighted that because we submit to someone's will willfully. And a will is somebody's instructions and rules and regulations. Since 1933, we've adopted new rules and regulations. I wonder why. What submission are we under? Or who submission are we under? No particular form of conduct is necessary to constitute a capture. Prizes are goods taken from the enemy of the high seas by right under the law of war. Under the maritime law, capture of an enemy's vessel, remember what I told you a vessel was, they all captures a vessel according to the GPO manual, confers title and ownership upon a captor. The capture succeeds to the rights of the owners of both the hull and cargo. The title of the captor or of the captor's government is enchoked, so it ceased to exist. Or it's incomplete, rather. However, in that it does not vest until condemnation by a prize court. So basically, until they do a prize court, this is how they capture your ownership of your title. It's not complete until they do a condemnation by a prize court, which is surrendered voluntarily, and the transfer of that title is complete. That's what they're doing every day in courts. They're capturing your vessel, deeming you to be an enemy, no longer neutral, and they're putting you in front of a prize court, traffic tickets, etc. As a general rule, an enemy vessel and cargo are subject to capture and condemnation as maritime prize. In addition, the vessel of a loyal citizen is subject to the capture and condemnation where it is employed in trade with an enemy. What I just tell you? Didn't I tell you that you're trading with an enemy? And this is what they say you are considered subject to capture and condemnation. Even if you're a loyal citizen, if you're trading with an enemy, you're subject. Okay? The flag is superficial evidence of a nationality of a vessel, but it is not conclusive. A country that seizes a ship flying a neutral flag may prove that true ownership of a vessel was an enemy and was in an enemy. On the other hand, under international law, a ship flying an enemy flag would not be permitted to show in a prize court that its true ownership was neutral. So if you're flying an enemy flag, you won't have the opportunity to say you got a neutral flag, because that opportunity was destroyed when you carried the enemy flag. The absence of irregularity of papers. My tongue twisting the table. Their defacement or destruction or the carrying of false papers justifies the capture and condemnation of the ship. Likewise, the condemnation of a cargo is legal where the cargo was not properly documented. So we ride around here with our little tribal IDs. They call those things false papers. Now, I'm not saying it's false, but I'm just showing you what they're doing, okay? The cargo, which is the vessel itself, wasn't properly documented, which is the car itself, right? The vehicle itself. I take a sip of this good old water. All right, let's keep going. A neutral cargo on an enemy vessel is not liable to condemnation as a prize. That's interesting, right? So you have neutral products on an enemy vessel, and that neutral product is not subject to the seizure. You could be riding your friend's car, and your declaration has been fully clean and good to go, right? You should have no problem. Neutral cargo, because your person is neutral. And a person is a thing. It's a mass. It's a persona. Domicile of owner. The domicile of the owner of property has an important bearing on his liability to be captured, to capture and condemnation. The property or interest of a person who is domiciled in an enemy country is liable to capture at sea. Well, where's your domicile? Do you have an address? Are you using numbers? Are you using zip codes? Notwithstanding the fact that he or she is a subject or citizen of a neutral country. So if you're a subject or a citizen of a neutral country, it doesn't apply to you. Or doesn't apply to you. Or other belligerent country, right? A person who has a commercial domicile in an enemy country by reason of owning or having interest in a house or business, there is within the rule. I'm going to stop here. And I'm going to come out with part 2 and 3 later this week. Kind of wrap this up where I'm going with this. And again, the goal is to give you my interpretation of what happened with the Trading with an Enemy Act and how it applies today, along with the Emergency Banking Relief Act 1933, how the creation of the Alien Property Custodian came about and why, what is a belligerent, what it means to have or be in a military occupation, and how all that relates to today, your vessel that you use daily, a driver's license, bank accounts, what have you. That's a vessel. Don't you forget it. But again, this is for educational purposes only. You need legal advice, you seek yourself a competent attorney. I suggest you do your own due diligence, your own research, come up with your own conclusions. And of course, share it. Drop your comments below if you have any questions or have any information to share. Even if you disagree, I would love to hear it. And why? This is your brother TWEA. I'm signing off. Peace, blessings, prosperity, equality, truth, health, wealth, love, and justice for all, right? Most importantly, because we're going through some hard times during this Corona season. Also, got any personal questions or like to reach out to me personally, you can reach out to me at do for self-restoration at protonmail.com. That's do number 4 self-restoration at protonmail.com. If you like the video or any other previous videos, or you feel like this is helpful to you, leave a donation. Dollar counts. $sign XiAmaruAli, which is XiAmaru. It's my Cash App. I will be again dropping video 2 soon. If you haven't gotten these articles or these books here, I suggest you do so. Again, it's Corporate Juris Secundum, War and National Defense, Section 24. That's where I'm starting. Well, Section 22 is where I started. This document here is entitled The Representational Function of the Alien Property Custodian of 1946 by James L. Duncanson. And this is entitled The Work of the Alien Property Custodian by Paul V. Myron. And I'm also reading from Law of Belligerent Occupation, JAGS Text number 11, the Judge Advocate General's School of Ann Arbor, Michigan. And of course, my GPO Trading with the Enemy Act. These are the documents or the sources I'm reading from. I suggest you get them and study them, and once you read it and get well versed with the information, contact me. Maybe we can have a discussion on it and maybe help each other clear up some of this fog here. Again, I'm signing out. You guys have a good one. Peace and wholeness.